a great turnout, as always. This is Angela Lopez with Cowles Thompson.
And this is Michelle Alonso with Cowles Thompson as well.
The recording has started.
So we are here today to give you an update on the latest government immigration changes, or creativity as we call it.
Yes.
Just to go over a few things, we will have a question answer session at the end of the call, but during the call you can type your questions on your pen and we'll see it here. We'll try to answer your questions during the call. During the call, we're also going to mute your phone, so you're not going to be able to speak, or if you speak, great, but we will not hear you. We will open the lines back up at the end of the call. For now, let me just walk you through the presentation. We're going to be talking about the proposed change to public charge rules, the new notice to appear. We have mentioned this in a few occasions before, but now it is in effect. The changes to the NAFTA, and TPS, DACA, and always H-1B and CAP updates. H-1B is always a subject that we want to talk to you about it, because it's always in the news. USCIS.
So a lot's been happening with them, and Angela is going to cover the proposed changes to public charge, because our phones have been ringing off the hook since this became published news. You see it on your online mediums. So Angela, please tell us, demystify what is this proposed rule.
Well, I don't know if I can demystify that, because no one can. But one thing I'm just going to say from the beginning, because this has been like the question of the month. Obamacare. Is that public charge? I have clients calling me, oh my goodness, we have been using Obamacare for the last 2 years, paying the premiums, doing things, and that's a government program. Is that public charge? Definitely it is not.
Perfect.
Because no one is giving you anything you're paying for. It's just that this is a program done through the government to facilitate people buying insurance, health insurance. So that's it. So no, it's not public charge. So
that's a huge clarification.
Yes. If you have been using it, please don't discontinue the use. Continue to use it. Take advantage of as long as it lasts. Now, going to the public charge. On September 22nd this year, the Department of Homeland Security announced a proposed rule to clarify, to clearly define the long-standing law related to public charge. This public rule is already up for comments in the Federal Register, and it was published on October 10th, so people can make comments from October 10th for 60 days. So that's going to bring us to December 20th. People can make comments about the rules and make suggestions and changes, and we know, as always, attorneys associations and a bunch of different people who deal with this area of the law, they are already making comments, trying to influence the final outcome, because after the comment period, they will revise, or they might attempt to revise, depending on the comments, and come up with the final rule. So that rule should probably be in effect sometime next year. Just to give you an idea, the public law charge it's been into effect, or has been the law for many years. I was kind of going through the history, and we can go as far as the Immigration Act of 1882. Can you believe
that's
that?
Going back really far.
Yes. So this is not a new law, because remember, many of the things that we see happening are not based on new law, but changes in procedure. This law has been there forever. What the government is trying to do now is to implement it. Imagine, it's been in the books since 1882, and we're just now going to go into implementation. So much for efficiency.
We're a little slow to act.
Yes,
just a little.
So going back in history, so we found out that in the late 19th and early 20th centuries, listen to this one, public charge was the most common ground for refusing admission at U.S. port of entries. So people looking to come into the United States, the government, the first thing they did was to look into whether or not there was a chance for someone to become a public charge, and therefore they were denied entry. So it's been...
So times are changing.
Well,
we got to revisit this, I guess.
I think times are changing because they want to go back to the 19th and 20th.
Were things all that much better back then? I don't know.
I don't know. So let's go over a couple of changes. The regulation that takes care of this, or that contains the basics of this law, is in Immigration Nationality Act, Section 212, 8 and 4. I think we're having some issues with the internet. Just please keep in mind we are in Dallas, Texas. And in case you haven't heard the news, we have been having some issues with the internet services here.
We have some 19th and 20th century rain coming
Yeah,
down.
so half of Dallas, I believe, for the last couple of days have had problems without internet,
The flash
without
flooding.
connectivity. And hopefully we're going to be able to get back online.
Yes, they can still hear you.
Perfect.
So we're just going to continue with the presentation. If you missed a few slides, don't worry, because we will be sending you a copy of the slide deck.
But Angela, you're mentioning that the Immigration Nationality Act has a specific law that states that if people cannot show that they can support themselves financially, that's a ground of inadmissibility. So the law you're mentioning has been on the books, and now we're finally getting that proposed rule to implement it.
And this is something also, not only that it's been in the books, but we as practitioners, I don't think that there is a case that we take on that we're not looking at public charge, especially when it comes to adjusting or becoming permanent residents. We are always looking at this because that's the law. It has always been.
Right, and I think that's important to point out. I know in our practice, we've had public charge disclosures for every case that we have filed. And my understanding is that maybe not everyone in the private bar has done these, so that's why it's also sort of become a new topic of discussion. But if anybody has had a case with our office, we've definitely done our public charge disclosures because we've known that this has been on the books for some time.
Yeah. So what are the public charge changes? Well, they're going to be looking at doing a bunch of different things to make sure people do not become dependent upon the government for maintenance or for financial aid. Some of the factors that they are going to be considering determining whether a person is likely to be at risk of becoming a public charge are age. Of course, it's not the same as when you bring someone who might be in the mid-20s as when you bring your parents who might be in the mid-80s.
Yep.
Age, health, family status, assets, resources, and financial status, education skills, and affidavit of support submitted by the alien sponsors. Affidavit of support, those are the forms that people have to complete when they want to bring family members to live in the United States. For employment-based petitions, we don't see affidavits of support. We see other kind of documentation. But they are going to be looking more carefully to the affidavit of support, because it's not only that the individual that wants to bring the family member to live in the United States saying, yes, I have the assets, or yes, I have the income to be able to support my family, but they want to make sure that the income or the financial situation for the individual is not something that might cease in the near future. So once the family member is in, then the person won't be able to support the family member.
Right, and we'd like to mention that the affidavit of support is written like a contract. So if you've actually looked at the form, it is the contract, and I think we've made that very clear in our disclosures that it's a contractual agreement between the sponsor and the government regarding this precise issue.
Yes, the affidavit of support. And the agreement is basically, yes, Department of Immigration, I do agree that I will, okay, I think that you are now looking at the slides, so you didn't miss any of the slides. We're just finishing up this one about the affidavit of support. So you agree with the government that you will support your family member, or that the government can come to you for help if they need, if they are going to be financially assisting your family member. Under the proposed rule, The following are the benefits that are considered public charge. So, temporary assistance for needy families, TANF, supplemental security income, Medicaid with limited exceptions for Medicaid benefits pay for an emergency medical condition. Take a look at the emergency nature. Implies that is one kind of a one-time thing.
Exactly.
It's not a constant or consistent help. And for certain disability services related to education. If you notice these three type of benefits, they are cash benefits. What people receive as benefit is cash, and therefore they have always been considered public charge and factors that might affect an individual eligibility to become permanent resident. The other programs that are considered public benefits are Medicare Part D low income subsidy. So if you see, this one is very specific. It's not just Medicare in general. It's the Part D low income subsidy. The Supplemental Nutrition Assistance Program, SNAP, or food stamps, okay? Institutionalization for long-term care at government expenses. And so here is where the perfect example is you have a person who might need special assistance or has health issues, an elderly person who needs to be at a government institution for a long term. Section 8, housing, choice voucher program. Section 8, project-based rental assistance. If you take a look at these programs, they're very specific. Again, they're not just talking about Medicare in general or Section 8 housing in general. They are very specific to specific programs within the program itself. Public housing. So when you're looking at determining, and here is how difficult this is going to become at some point, because it's not just, oh, well, I received some public assistance. Okay, well, what type? Then your subject. No, it's going more than just that, because we will have to look at the totality of the circumstances to determine whether or not that might affect the chances of a person to becoming a permanent resident.
So, right, we haven't gotten there yet, but you're just pointing out sort of the programs are going to, one of the factors that they're going to look into is whether or not you're getting help from any of these programs.
Exactly. But so you know that these are the programs that the government considers public charge benefits.
And I think you pointed out, and I think it's important to emphasize that this is one that is generally equals a cash value. There is a cash value that's tied to all of this.
Well, at least the first three programs. The others do not necessarily have cash value, but they do imply government assistance.
Excellent. Okay.
Now, what are the categories that are going to be affected? Well,
everything.
Pretty much everything. Yes, they were very careful to say. They would have saved time if they say which ones were not going to be affected.
Excluded, right?
Yes. So the ones that are affected at most family and employment-based categories. Again, we go back to adjustment of status. And the family-based, you always see affidavit of support. And the employment-based, what you're going to be looking at is probably those programs that are for self-sponsorship.
Exactly.
Because you have to make sure that you not only are sponsoring yourself and you meet those requirements, but also that you're going to be able to provide for yourself
and your family
in the future and your family members. Non-immigrant categories, this might sound weird, but it's true. When you have someone coming on a visitor visa, we already have that. They have to show financial capability to support themselves when they're coming to the United States to visit. Same for students and F visas.
I think this one hits students particularly.
Yes. So look at that because they want to make sure. Other visas, we're looking at probably religious visas, ours. Because, yes, although in those categories you're not subject to having a specific minimum amount of salary, some of those might not meet the public charge rule. Adjustment of status, permanent residency cases, and non-immigrant extension and change of statuses. We just mentioned those. Now, the categories that are not subject, and some of them are just kind of logic thing, kind of a given. Refugees, asylees, well, obviously, if they're here, they're coming to the United States, or they will be coming into the United States in precarious situations, so it would be very unfair to hit them with the public charge rule.
Agreed.
Supplemental security income. So if you notice there, we mentioned that one before in the ones that could be considered as public charge, and we said supplemental income, security income, and then here are not going to be in charge is because it is only certain parts of the program. Some other parts are not considered public charge.
Right, and I think we were explaining that to someone the other day. Like, if you are getting SSI benefits, it's not just, okay, you got SSI benefits, you're out.
Yes.
We have to look at under what conditions did you get that
Exactly.
benefit.
And it goes back to cash value.
Exactly.
Okay, so certain non-immigrant categories like the U and T visas for those of
Victims
you,
of crimes and victims of human trafficking, obviously, the government is not going to press them to show that they have
the
assets.
concern here is not financial. The concern here is to protect the individuals.
Yes.
And consular process. Listen to these ones. So we might want to start consular process in all of our cases.
I think this is a push to consular process.
Yes, consular process cases are not subject to the public charge rules because they are under the Department of State jurisdiction and not under the Department of Immigration. So this is
where I struggle with wrapping my head. So, consular processing cases under the Department of State versus adjustment under USCIS. They both touch on the same law, but do they both operate with the same guidance?
That's the difference.
Exactly.
Because the Department of State operates under the FAM.
Yes, the Foreign Affairs
Federal-
Manual.
Exactly, Foreign Affairs Manual. And the Department of Immigration operates under the
DHS policy memorandums.
and
policy
the INA,
Yes.
Immigration Nationality Act, two different set of rules. However, let's not confuse that with if you are immigrating to the United States based on a family petition, you still have to do the affidavit of support.
Absolutely. And
And you will still have the contract.
Absolutely. And I'm going to add that right now we've seen cases that are going through Mexico on family-based cases that the consular officers are saying that as a result of a public charge, they're not letting them come through. And we've been working that out with different advocacy groups. So public charge you will see on these consular process cases, but it's not coming under this proposed rule. And I think that's an important distinction.
Exactly. So those are things we need to continue to fight.
Yep.
But you still have to do the affidavit of support.
Yep.
And the thing is that once the person comes into the United States, then for future renewals of the visa or to change the status or do something, then they will come under the jurisdiction of the Department of Immigration and then public charge will apply.
Exactly.
Okay, so that's what we need to be careful with, even though it might not be a factor to determine whether or not the person can become a permanent resident or immigrate to the United States or be in the United States, public charge related at the Department of State when they go to the consulates. Once they enter the United States, that's going to become an issue. So we always want to make sure that even though there might not be subject when they are going to the interview at the consulate, we want to make sure that they won't become subject once they are in the United States, because that might be a problem in the future.
Exactly.
So we do look out for those things from the beginning. Another categories that are not subject are benefits received by aliens serving in active duty, more than fair, or the ready reserve component of the U.S. Armed Forces, or the spouse or child of the service member. So anyone who is in the service, the ready serve components, spouses and children, we don't have to worry about public charge because the nature of the service.
Right, and I think what is fairly topical is also not subject or disaster relief. And so
Exactly. So those are not included. Other categories that are not included is emergency medical assistance, and we mentioned that at the beginning because of the nature of the situation is an emergency. It might be just a one-time type of thing. And emergencies, as we know, those are unpredictable situations, and if you need the assistance for just a moment, that's not going to affect the overall case. Benefits received by an alien, U.S. citizen children.
I think that's one that it needs to be emphasized, because a lot of benefits that are accorded to U.S. citizens will come to the benefit of the children, even though the family has immigrant parents. And that's a distinction that has to be made and sometimes advocated, because we don't know how far they're going to press for this public charge. But you mentioned this is a factor-based, so that's going to be another factor that says the benefit is not coming to the parents, but rather to the children.
Yes, and that's another thing that we have been talking to people about it in the last couple of weeks since the announcement, because many people who are already here in the United States and they are looking to become permanent residents, their children are citizens, and those children are receiving some public benefits, and that doesn't mean they're public charge. They are U.S. citizens. They are entitled to the help, so that will not affect the parents' case because they are U.S. citizens. Now, some of the factors that are going to be looked at when determining whether the person or the individual might become public charge, they kind of put them into two categories: negative factors and positive factors. So the negative factors are a person who might not be able to become employed or lack of employability, current receipt of a public benefit, or receiving one within the last 36 months. And last 36 months, we're talking about from the moment the immigrant benefit petition has been filed. So don't look back 36 months from now when you don't have anything pending with immigration, because that doesn't matter. It's from the moment you file those petitions. So in some cases, we might just delay the filing of the petition to wait for those 36 months to go away. Financial means to pay for medical costs, previous finding of being a public charge. If at some point during the time in the United States a person has been rendered as a public charge, more than likely that is going to affect future findings. So that might affect any petitions that are filed with the Department of Immigration. So those are the negative factors. So the positive factors, of course, there's only one, and you got to be kind of rich. Positive factors are related to income. If you are over 250% of the federal poverty guidelines, then you're fine.
Okay.
So you better have money in the bank, not to be looked at for any public charge issues.
Wow.
What we just, and this is very fast, this is very general information. These are the things that are going to be looked at. The proposed rule has over 400 pages, and we just try to put here the things that are going to make these rules work in favor or against you when you're filing. And the basic, and I think that this gives us a little relief, is that when you take all of these factors, all of these categories, all of these programs, what matters is the totality of the circumstances.
Yep, that's the
So,
test.
like Michelle mentioned before, not just because you receive a specific benefit, then you're going to be out of the loop, or you're not going to be able to become a resident or get that temporary visa or anything, because we will have to look at the overall circumstances to determine yes or no.
And I'm going to mention right here, every time we do these webinars, I always tell Angela, we don't discuss a lot of proposed rules because they're not final, but this one was really important because of the calls and the concerns from clients about it, that we covered just the proposed rule.
Yeah, but also what we need to make emphasis here is once the proposed, and I have never seen a proposed rule that is up for comment that didn't become the rule.
Oh no, it's coming.
So
It's
this
coming.
is the proposed rules. We make a point not to address them when they are not even in the comment period. This one is in the comment period since October 10th, which means that in 60 days, they're going to close the comment period. They're going to be looking at what comments were made, our experiences with comments is that sometimes
Sometimes.
they do take into account the comments to make changes to the final rule. So they might take into account some of those comments, and we might see, I'm thinking we're going to see a very similar rule, probably with a few changes, hopefully with big changes, but we don't know. But there's going to be a rule in effect, and more than likely sometime beginning of next year.
Yep, I agree. This was definitely one we couldn't pass up.
Yes, so stay tuned. So we'll give you the final draft that is probably going to be, instead of 400 and some pages, 500.
500.
Yeah. So it's going to be a fun reading.
So, aside from this public charge rule, something else took effect beginning October 1st. We had discussed this and touched on it back in 2017 when enhancing public safety in the interior of the United States, that executive order was passed in January, soon after President Trump took office. So then, fast forward, we explained that we'd probably start seeing the administration shift in that direction, and they did. In June of this year, they crafted this guidance that was published July 5th to go into effect October 1st. So what is this new notice to appear policy all about? You'll see up there in bold red, it's about enforcement. We've been talking for several years, 2 years now, that this administration is one that's taken an enforcement approach, and they are hitting full throttle with the parameters that are built into the law. The NTA policy is significant because a notice to appear is the charging document, or it's the document that initiates deportation proceedings or removal proceedings for a foreign national. It basically says, okay, wait a minute, now you have to go talk to an immigration judge about whether or not you can stay here. That's really sort of plain Jane, simple terms about what this NTA is. It's going to allege whether you're a citizen or national of what country and what basis that the government could move on to remove you from the country.
Yeah. And we're already seeing NTAs. They started on October 1st, and in our office we have received a couple of those NTAs, and I know attorneys all over the country have been coming out, letting people know we got the NTAs, and so they are working hard on getting those NTAs.
And
out.
I'm going to be very honest. I knew this was coming. I saw it. I've read about it. And until that case walked through our door, I didn't believe it was happening, but it is. So we do have a situation that we ran into where we had an F1 student who overstayed, technically, I think it was 26 days. And they initiated and issued him a notice to appear. So this is happening, and it's for real. So impact on DACA recipients on this new NTA policy. The good thing about DACA recipients, you are under the control of the 2011 NTA memo that was in place. 2012 memo. So unless you're getting into any criminal issues, as long as you have a clean record, DACA recipients are still going to be afforded that deferral of action on removing them.
But that has always been the case.
Exactly.
One of the things that had prevented, just period, many of the individuals that qualify for DACA was to have a criminal record, and they couldn't file for DACA. So if they now have DACA, and then they add a criminal record, they're going to be out of the DACA program very quickly.
Very quickly. Impact on TPS beneficiaries. TPS, just like DACA. If you have no basis for removal and you have that protective status, even if you had a removal order in place, while that TPS is current, they will not remove you. They're not going to move forward. So
you're
that's
still protected, right?
Still protected. F1 students. Okay, so this one touches on the one that is hitting our practice a little bit. August 9th, 2018, USCIS published a policy memo about how they interpret the accrual of unlawful presence for FJs and M non-immigrants.
But what is accrual
of unlawful presence? It's a little technical. So when someone is here without status, generally they either entered with no visa and were not inspected, or they were inspected and they have overstayed the period that was previously prescribed.
Which means they came in as visitors or students or in some other type of visa, and then they just stay?
Yes, so
beyond the authorized period?
Authorized period. So many, many years ago, you used to get a white document, a white square that was your I-94, and on that it would be stamped the period of which you're allowed to remain on that visa. So if you came over on a B, for example, generally speaking, you'll get a 6-month I-94 period. Now, since 2013, the government switched to electronic I-94s. People don't get the little white carton, the little white piece of paper anymore.
But they get the I-94.
But you're going to have an I-94. You'll have to go online and look and see what the period is. And previously, F, J's, and M's would get a D over S, which was duration status. Because normally, if your F program is 12 months or 3 years or 5 years, whatever the case may be, so long as you keep complying with your student status and going to school and not working without authorization, you could remain legally in status. Mm-hmm. Well, there's multiple reasons why, and we won't go into it, but there was a study, and they believed that one of the things that the government should do was implement this accrual of unlawful presence, that mm-hmm. students who quit going to school should be like everyone else who, like, overstays a tourist visa or overstayed their H or their L, that they should also be subject to the accrual of this unlawful time. Why is that important? If you want to adjust status down the road or you want to change status, if you have this impediment, you will not be able to.
Yeah. So, in other words, if you stop doing what you're supposed to be doing.
Precisely.
Meaning, if you stop going to school, if you stop working, or if you're going to school and you start working when you shouldn't, or if you know you are allowed to stay here until December 30th and you decide to stay, then you start accruing. Unlawful presence means you're here in the United States with authorization.
Right. And I think it's important because we have a lot of clients that will come over on one particular visa and come in one status. Mm-hmm. And for whatever reason, they'll change status to another category, and then they'll bridge that one to another status. And so you have all these multiple changes of status that come down the road. If at any point in time you violated or didn't do what you're supposed to do while you were under that particular category, it throws the whole chain of your legal status and your legal stay here. That could be a big monkey wrench when we're looking down the road for adjustment of status. So this memo that came in as of August is definitely one that needs to be examined. I know I've had clients, we've had clients where if, say, they confess that they worked at a corner store while they were doing their graduate school programs because they need a little extra money, we'll send them out and have them come back in so they have a new admission period, and we don't have that working without authorization to break the chain. So that's just one example. So this new NTA policy, it's in place October 1st. And we're a couple of days into October, 2 weeks into October, and it's the real deal. Now, I will mention that the notice to appear will have to be filed with your local immigration court that has jurisdiction over your case, and that's where you'll get generated the notice of hearing, and that's when you should show up to court. So that's all I have on that.
Yeah, well, that's plenty. That's a seminar or webinar in itself.
Yes.
So now we go with the other update and something that has been in the news in the last couple of weeks, and it's NAFTA. Well, NAFTA has been in the news since before President Trump took office, because that was one of his campaign promises, that he was going to be looking into terminating or renegotiating NAFTA. Well, they start talks, I think, before he came into office. And finally, just on September 30th, they announced that they had reached a new agreement with Canada and Mexico. And now it is, the NAFTA now is called USMCA, U.S., Mexico, and Canada Agreement. It has a bunch of changes, and we're not going to go through NAFTA because that's not the subject of the conversation. I think and I was writing an article about it, very positive changes for the United States and even for the other countries. What we really care for is the TN visa.
Yep. And
fortunately, that chapter, which is chapter 16 of the original NAFTA, now USMCA, the chapter 16 remains untouched.
Right.
So we still have TM visas. We still have over 60 categories of occupations
yes.
that qualify for visas. Mainly is for professional workers. We know the requirements go from an associate to a bachelor's degree, and in some cases requires licenses if the profession requires a license. The TN visa is still for 3 years and is still renewable indefinitely as long as the requirements are met. Dependents can come on TD visas, and dependents are spouses and children under 21. So we still have TNs, and that's all we kind of care for about NAFTA at this point.
Right, and I think, as you mentioned, some of the favorable changes were also to the business activities that are allowed for Mexican-Canadian professionals also that aren't generally accorded to B1s from other countries. So that's always a bonus. But basically nothing really changed.
In terms of immigration, didn't. In terms of all the other trade and business and other things between the three countries, there's been a big change, especially when it comes to intellectual property. They are now implementing or addressing intellectual property that it was left out from the other one.
Perfect. So at least we got that up to date. So will my TNs be able to renew?
Of course.
Yes, perfect.
We're
I love
doing
it.
it. Keep doing it.
Keep doing it.
It's here to stay.
Okay. So, and of course, in continuing with government updates, TPS warrants a mention. This was interesting. This slide kind of came in because on October 3rd, a federal judge out of California, Judge Edward Chen, issued a preliminary injunction temporarily blocking the termination of the TPS program for TPS beneficiaries of Haiti, El Salvador, Honduras, and Sudan. So what happens is they'd already announced the term of these TPS programs, and then there's a group that came out and has started the litigation, and we're seeing already this federal judge who's put a stop to that. According to the ruling, the government must maintain TPS and employment authorization for these beneficiaries of these countries while they're done challenging it. So it's mentioned only because it's putting a pause to the termination. Of course, we saw this with DACA litigation. This could drag out. So at this point, we just need TPS beneficiaries who do not or have not looked into what alternate routes or alternate ways they have to remain in the country. Please consult, because there are employers that we're working with on a couple of cases. With TPS beneficiaries, there are a few avenues that are still available. So this is maybe a slight grace period. And if you didn't do anything, then now's the time to act on it.
Yes, and if you know you're vulnerable on this end, please take the time at least to speak with an immigration attorney about your options and start acting on them. Don't just wait for the litigation to be resolved, because it might be resolved against instead of in favor. But also, and this is one of those things that really make me I'm not going to say upset, because that's not the right word, but it
gets you worked up.
Yes, a little, because here is where I always say, well, Congress should be doing its part.
Of course.
Congress should be enacting something to preserve these rights and to keep people here. But then we're left to what the courts decide, and you don't want to be there, so do your part and consult with an immigration attorney as soon as you can.
Angela, Congress also passed that law in 1882. They just got around to putting a rule out there, so,
Yeah, but litigation is not going to last 100 years. I promise you that.
No, but it's a good segue, because, of course, we want to address now DACA recipients and a Dreamers update. And as you so perfectly highlighted, we're stuck in legislation. And nothing is happening in Congress. No one is coming in to really do anything for these young folks, which are not young anymore. So where are we with DACA? Just to give you a quick update, no initial DACAs are being accepted. No. But because of the litigation, DACA renewals continue. Last month we sent out an alert, August we sent out an alert because of a case that's pending here in Texas. And we were afraid that the same judge would grant the government an injunction. He didn't. So at this point, DACA renewals will continue. We've been telling folks, even if you're outside of the filing window, go ahead and renew. So at least you would get an employment authorization through 2020, because we're so uncertain about how this litigation is going to pan out.
Yeah.
again, but that's really at your own risk. If you have one expiring in 2019, we have advised several clients to file so they could have theirs to cover them through 2020. So if you file now, it'll be 2018 through 2020. It'll be your 2 years. My opinion, it's $465 is well worth it. But again, if you have DACA, I wish we had good news, but we don't. It's
Well,
just,
I think it's good news in terms that we can still do renewals.
Renewals, yes.
So everybody who is already in the system and has DACA, they can continue to renew.
yes, and if you let it lapse, try to renew.
Yes,
yeah.
and that's a good point.
Yes.
Because not just because your DACA expired and you didn't renew it on time, then you're now out of the option of having a DACA. No. Filing, as long as there are no criminal records,
Right.
that would be a no.
Right. It's still not considered an initial. It's a renewal.
Exactly. So the only thing that you'll have to look for is that if the DACA expired more than a year ago, then if you're filing for renewal, you're going to have to submit all the documentation that you submitted when you first obtained your DACA, as opposed to just a couple of papers with the renewal. But you can still renew.
Yep. And so I think we're making good time.
Well, yes. Now, H-1B updates, H-1B caps, where are we on these?
So what happens is there are still thousands of H-1B cap cases that were
Pending.
filed and remain pending.
Yeah.
So I think the government just did a workload transfer from one service center to the other with a lot of these cap cases. But that's putting our employers in a very precarious situation because
Not to mention the employees.
and the employees. But so you've done everything right. You filed on April 1st. You have been waiting patiently. You can't do premium processing because they suspended premium processing.
Except for those institutions that are nonprofit and that are affiliated with institutions of higher education. Those can premium process.
Right.
But everybody else has
Has
to
been
wait.
stuck in this line. And so oftentimes we've always told people about, don't worry, you have gap protection, you're covered until September 30th. But what happens if I still have a pending petition and it's October 16th?
Yeah, that's a good question. You should have stopped working on October 1st because
Exactly.
once your gap OPT expires, which remember, OPT gap is those students who are here with the temporary work authorization. Once they file the H-1B under the CAP system, if they get a receipt notice, meaning they enter into the lottery
Yep.
and they're going to be able to process the H-1B, then the OPTs are extended at least to September 30th because by law, immigration is supposed to process those H-1Bs before October 1st so that the individual can continue to work. Well, that is not happening this time. So if you OPT expire on September 30th, we're sorry, but you should be out of work since October 1st.
Right.
What is happening in the meantime? Well, USCIS continues to process the H-1Bs. There is no premium process, but there's an option to expedite.
Right, there's expedite processing that is available if you meet one of the criteria. You have to call them to initiate that, and we could definitely be of assistance. But I think it's frustrating for employers and employees alike that you haven't been able to work since October 1st, and you're still waiting for this process to complete.
And don't think that the expedite process is fast.
It's not.
It's not.
It's not expeditious at all.
Exactly. So it may take some time, in weeks, in cases, a couple months, you might get a denial that no, they don't consider that you being without an income, not being able to work, and having to pay all your expenses. That might not be a factor to consider when you're asking for the expedite
Now,
process.
these people are in a period of authorized stay. They're not accruing any unlawful presence. They're in a period of authorized stay during the pendency of...
Authorized stay means you can stay here, but you cannot work.
Exactly. No work authorization.
You're still out of a status, though.
Yes, but where does the grace period come in now?
With the F students.
Yes, with your F students, we want to make sure that you're very clear that unless the case is denied, rejected, revoked, or withdrawn, after the date of that decision, you will have your 60 days to leave. So
if your H-1B is when it's decided negatively, because if it is approved, then you are in H-1B, you can start working and you're fine. But let's assume
The worst.
the worst. The H-1B was denied. You still have 60 days.
Yes.
To leave the country. F1
Unless-
students have 60 days after the status expires. So you have the 60 days
Unless it was denied due to a status violation, misrepresentation, or fraud. So these are very serious charges. And again, we go back to status violation.
Yeah.
The number one status violation is you worked without
Yeah,
authorization.
and if you have any of these charges, the list of your concerns is going to be the 60 days.
Right, and this is where you want to remember, if there was a status violation or misrepresentation or fraud, you're also going to fall under the purview of that new NTA policy, and you could be placed in proceedings.
You can get the NTA.
Yes.
Okay.
So again, a 60-day grace period does not apply for those who were revoked based on those aforementioned. That's really all we wanted to kind of touch on to remind folks about this H-1B, F1, OPT, CAP-GAP folks.
Yeah, so if you have any concerns about your H-1B and maybe you're thinking, oh, it might be denied because of one of these violations, you might want to talk to us or an immigration attorney about options because it's about preserving your possibility of doing something in the future.
Exactly.
It's more than just the 60 days grace period. So with that, we're going to open our lines for questions. To ask a question, please press